Hear ye, hear ye, hear ye. The Colorado Court of Appeals is now in session.
Please be seated. Welcome to Division 1 of the Colorado Court of Appeals. We have two cases on our docket this afternoon. And the first case we have is People v. Marquez. Counselor, both seated at the table. I know you're both experienced appelleteers, so I'm sure when you got your instructions when you came in, you probably don't have many questions about them? No questions? No questions?
None, Your Honor.
Okay. And there is the 2 o'clock case. The attorneys here for the 2 o'clock case yet? People in the interest of NA? Are they here? They are not here?
They just stepped out.
Okay. All right. If you remember, we have our arguments 15 minutes aside. You know, the yellow light will come on with 5 minutes left. Appellant, you're in charge of your own time as far as rebuttal goes. If you've got something confidential or sensitive, remember we are live streaming as well as we are archiving our oral arguments, so please be careful about mentioning anything that's confidential or sensitive, victims' names, young children's names, things like that. When you come, don't forget to tell us your name and attorney registration number. For those in the audience, please turn off your cell phones and pagers so as not to disrupt our arguments. And I think with that, I think we can begin our arguments in People v. Marquez.
May it please the court, counsel, I'm John Carlson, 28263, I believe is my reg number. This appeal arises from the denial of Mr. Marquez's 35C petition, which alleged ineffective assistance of counsel arising from a plea offer Mr. Marquez authorized on March 1, 2012, one day before the trial readiness conference. The issue before the court is whether defense counsel conveyed that offer to the prosecutors. The district court, post-conviction court, found that he did, doing so in an email dated March 1, 2012. The district court's finding is mistaken, and I make that claim mindful of the high bar I must clear. But a mountain, an abundance of facts contradict and undermine the validity of that finding. And I'd like to spend, I hope, much of the remaining time identifying those contrary facts and discussing why they're important. Let's start with the first. There's no copy of the email in the defense counsel's files, nor is there a copy in the prosecutor's file. And that includes—
I have a question about the prosecutor's file. So from the testimony that was presented at trial, it sounds like the prosecution kept paper files at that time, at the time of the original trial. And it's unclear to me from the record whether the prosecution, I didn't see any testimony that they would have printed out emails for the paper file. And it's pretty unclear to me whether they looked at or even had access to emails on a server going back that far. Am I mistaken? Is there something else in the record that leads you to say that there's no copy of the email?
Well, it's a fair point, Judge Lum. And you've put your finger on some ambiguity. But let's recall that the prosecutors had every incentive to bring forward an email. What you will not find in this record, in the discovery request to the prosecutor, the subpoena that the district court signed, is any specific demand that the prosecutor search their electronic archive emails. And I'm thinking that might be what you're referring to. On the other hand, the second chair prosecutor, who did step into the first chair and try the case by herself, said she looked for emails at the 35C testimony. And she, remember, had every reason to find an email because it would have ended Mr. Marquez's case in its tracks. And she told the post-conviction court she looked and could not find any emails. That's not the end of the problem for the district court's finding.
Pardon me, did she say where she looked?
She looked in the files.
Okay, and as Judge Lum said, right now, we know that there was a paper file.
We do.
She didn't specifically say, I did an electronic search, did she?
That's correct, Your Honor.
Thank you.
She did say, I looked in the files. She looked at the jacket cover, found no indication of receiving a plea. More to the important are two additional facts. Well, before I get to those additional facts, of course, both prosecutors testified they had no memory of receiving the March 1 email, for which I do not fault them 10 years later. More to the point, they each said defense counsel never made a plea offer, full stop. In addition to that testimony, there were two additional facts that are quite important, I think, because reconciling the district court's ruling with these two facts necessarily means the district court presumed that two experienced prosecutors in a large district attorney's office breached mandatory duties, one statutory, the other the product of an internal office policy. Both prosecutors testified there was no so-called green sheet in the prosecutor's file. So important is a consult with a victim over a received plea offer that the prosecutors document those discussions with a different colored piece of paper, green. The prosecutor said there was no green sheet in this file, something that they were obligated to do, that is to consult with the victim on a meaningful plea offer and record the victim's position. It's not in the file. Not only that, Your Honor, all three of you, pardon me, is the prosecutor said that a long-standing policy in Weld County is you don't accept a plea offer. You don't consider a plea offer until you get a supervising attorney, prosecutor, to endorse it. There's no record of a consult with such a supervisor in this record. There is not even the defense counsel himself said he sent the email. He couldn't recall. What he said was, I'm sure I did, which leaves the sole fact supporting this finding. You know it quite well. It's a notation in the defense lawyer's file. It too doesn't say, I sent the email. It says, see email to. That fact simply does not stack up against the 8 facts.
Was the email that comment referenced, did it have a date on the email?
No, sir.
It did not have a date?
It said, see email to DDA, Deputy District Attorneys, with 4 or 5 letters, clearly signaling the intent to send an email to the Deputy District Attorneys by the names of, listed by the initials.
My understanding was that there was a date by the notation. It doesn't say see email dated, but there is a date by the notation.
True, all of this, I apologize if I misunderstood, Judge Daly. There is a date at the top of the note.
Okay.
Dated March 1.
No, you didn't misunderstand. You understood perfectly, but I was interested in the follow-up that Judge Lum clarified, because I was about to say, did they find any emails at or around that date?
No, they did not, subject to Judge Lum's very fair observation that there isn't crystal clear evidence here that they searched electronic databases.
Or that they had access.
They certainly did. By 2021, when the hearing occurred, they had every ability to search.
Oh, I'm sorry. I meant that it was unclear to me, I'm sure they had an ability to search in 2021. The question in my mind that I know we're not going to really have an answer to is whether they had, whether there might not be some other purging of emails that happens in the time period between.
It's possible. What I was referring to was we don't have the problem that we have with respect to the public defender's email, which was an affirmative statement that those emails were eliminated 31 days after defense counsel departed the office. So in the end, I guess it's not my place to ask you a question, but the trial judge posed a rhetorical question in his order, so I feel some license to do the same. What are the chances that the 7, 8, depending on how you count them, facts that I've just listed exist at the same time the district court's fact exists? It's not zero, but it's much, much closer to zero than this court can tolerate affirming this ruling.
Well, that brings me to a question about, sort of the standard for clear error review. We certainly have case law saying that we can't overturn a district court's factual findings unless there is no support for them in the record. We obviously have some support. I understand that you're saying it is outweighed by the other facts, but what's the authority that you're referring to say that we can reweigh those
People
facts?
versus Kaiser.
Okay.
And I mention that specifically because I'm going to pick a small bone with your, I think, cramped definition of clear error. No support in the record is 1/2, but Kaiser says, or clear error. Those are distinct concepts with a disjunctive, not a conjunctive.
How do you find clear error? Isn't the one defining the other?
Perhaps, but I think there's a standard appellate definition in state courts and federal courts that attaches to clear error, and it's this. Are you left with the firm conviction that a mistake was made? I think you are here.
There are, that's a federal standard, and there are occasional Court of Appeals, Colorado Court of Appeals statements to that effect.
Yes, Your Honor. If there are no further questions, and I don't mean to hustle you off, but I will make room unless there are. Thank you.
Good afternoon. May it please the court. Jessica Ross, registration number 44927 for the people. I'd like to focus on two main problems with defendant's argument corresponding to the two prongs of the Strickland standard. First, as to deficient performance and the court's factual finding, this challenge, defendant's argument does not correctly apply the clear error standard. And second, as to prejudice, defendant's argument doesn't recognize that the court's conclusion there is independent of its factual finding that trial counsel conveyed the plea. So turning to the first point on clear error. So defendants' call for this court to set aside the district court's factual findings fails as a matter of law and fact. Legally, and I'm not going to mince words, clear error is a highly deferential standard, and it looks simply to whether the court's factual findings are supported by the record. It does not measure whether the court's factual finding is supported by the weight of the evidence. And that is what defendant is asking this court to do. One of the cases cited in our brief, Curran, makes this clear. What weight to give the evidence is a question for the trial court. Factually, though, turning to the record here, it amply supports the court's finding. The court was tasked with resolving conflicting evidence on the point, did counsel convey this plea or not? And the court resolved it by saying yes. And that finding is supported both by trial counsel's testimony at the hearing, trial counsel's contemporaneous file notes, as well as shored up by the court's credibility determinations as to both. So turning to the testimony, yes, because of the passage of time, all of the attorneys involved here didn't really have an independent recollection of doing much in this case. But the counsel did say I'm sure I did. And I think we all agree that that's what he said. But he was referring to also his contemporaneous notes in his file. And those specifically, I think, indicated an email was sent on this date, the earliest that defendant had apparently authorized counsel to offer what was a 5 to 10 year plea on an F3. And the court below specifically found that to be a credible and reliable source of information. And it was really those notes that I think tipped the scale for the court, because as counsel noted earlier, the court said, why would this be in the file if it didn't happen? And the court really weighed the evidence in favor of finding that. So to argue otherwise, counsel's argued that there's all of these facts that stack up to show that the court was wrong. But that tactic is unpersuasive legally and factually. Again, legally, clear error review says appellate courts defer to trial court's factual findings, even though a contrary position may find support in the record, and even though this court might be convinced of that contrary position.
Counselor, are you aware of the number of cases in Colorado that will articulate the clear error test in an alternative fashion, and that is whether or not there may have been evidence to support? You have the state of the evidence is such that you have a firm and definite conviction that an error has been made.
Yes, those iterations are set in case law, and I think there are several ways to describe clear error review. The important thing is the application of it. And under no application of it is this court permitted to reweigh the evidence to substitute itself for the trial court, particularly on something like this where there is conflicting evidence. Not only that, but the court below was in the best position to weigh it, to see the witnesses testify live and to have all of it before it to make these different weight determinations and credibility determinations. So first off, I think this court shouldn't be going down the road of looking at all of these additional facts, but if the court has any questions about it, I'm happy to go through them. I think factually, as defendant notes in his brief, there is a universe where all of these facts are compatible. So the absence of evidence, which is most of the things that defendant is pointing to, can be explained consistently with the trial court's conclusion. For example, the point, Judge Lem and Judge Bernard, that you brought up earlier to counsel about the emails not being in the file, I think the record does indicate that they were looking at were there printed emails in the district attorney's files. And of course, the trial court resolved this question for us and in its order said, well, the explanation for that is that counsel just didn't print the emails. And those kinds of examples abound. I think it's also important to remember that the hearing reflects that this plea came at a time very quickly or very shortly before trial. And one of the district attorneys testified that by that time, it was really highly unlikely that she would have accepted any offer. And I think you have to remember that context if you're going to evaluate some of these other facts defendant claims make the difference. So this idea that this wasn't elevated to a supervisor, it wasn't presented to the victim, all of these make sense if you believe, as apparently the district attorneys did, that this plea would have been unacceptable in the years it offered and when it came. Because we also have testimony from at least one of the district attorneys that said 10 years was the minimum acceptable term that he would have considered in deciding whether to engage in these negotiations. And recall, this was a no offer case from the beginning. It was a very strong case for the prosecution. So with that context in mind, all of these other things about, well, the prosecutors violated their duties, I think is colored a little bit differently. Ultimately, though, this fight about the evidence just highlights the problems with the defendant's argument, because whatever persuasive force they may have had, they should have been made to the trial court, because the trial court was the one that was resolving this in the first instance. Because the findings were supported by the record, I think this court's job is fairly easy in this case. It can affirm for that basis. But I want to just, unless this court has other questions about that point, I want to turn to the second point, which is there's an alternative basis to affirm here where this court doesn't necessarily have to address the factual challenge because the trial court's prejudice conclusion is independent of that finding. So recall, defendant's claim was that trial counsel was ineffective for not more aggressively pursuing a plea resolution in this case. And in order to prevail there, defendant had to show deficient performance, but also that he was prejudiced by that deficient performance. So even assuming there was deficient performance, the district court found defendant had failed to show prejudice. And it was because he didn't show that there was a reasonable probability that both the prosecutor and the court would have accepted this 5 to 10 year plea. And I want to emphasize that the findings the court made are independent of its finding about the conveying. And it did, I will say, in the order, it gave several reasons why it thought that prejudice had not been shown. One of them is related, and that one goes to, well, the prosecutors didn't accept this plea, so obviously you weren't prejudiced, even if the defense counsel's performance was deficient.
And you would agree that that's a little bit circular.
That's definitely related. But the court didn't stop there, and had it been the only basis, it could have. I'd also say the court did not have to go on to address prejudice because either one of these prongs would have been sufficient to deny defendant's claim, but it did. But it didn't rest its decision solely on that point because it also went on to address the prosecutor's testimony where she said, this, like shortly around pretrial readiness, which was about the time that this plea would have been conveyed, it was unlikely we would have accepted any offer that close to trial. So the court relied on that to say, you're not prejudiced for that reason.
Is that what she testified, Ms. Carrasco, is that what she testified to, or was that, my understanding is that sort of the cutoff date would have been that pretrial readiness conference, and that this would have sort of just snuck in under that wire.
Yeah, I think that's right. It was an approximate point, I think. She sort of said once Mr. Luna, the other DA, was off the case, and we know from his testimony and others, it was around the time of readiness. It was all kind of contemporaneous with that. But that's consistent, I think, with the other attorney's testimony too, that this is only a few weeks before trial, and at that point, everyone is ready to go. They have a very strong case. They're inclined to proceed because they thought they could win and get a correct result there. But not only that, the court went on to address whether the court below, the sentencing court, would have addressed this, and said it's unlikely a court would have, given the aggravating facts in the case and defendant's criminal history. So there's multiple layers that can support the trial court's prejudice finding, which is an independent basis for this court to affirm.
What was the basis of the trial court saying, the sort of underlying factual basis for the trial court saying that the court below wouldn't have, it wasn't likely they would have accepted the offer, where the defense produced evidence of prior pleas that had been accepted?
Well, a couple of points. I think the court just said the basis for my finding is the aggravated facts in his criminal history. In terms of how it dealt with the summary, the court kind of seemed like it set it aside in a way. On page 482 of the record, the court acknowledged defendant's Exhibit F attempts to summarize these other cases, but it says also lacks information about the individual circumstances of each case. So that includes the aggravating circumstances in the criminal history. So it appears to me from that record that the court sort of cabined it in that sense of not being as helpful as it could have been with that fulsome information. So because those findings are supported by the record, that's an independent basis for this court to affirm. But because ultimately defendant had the burden to ensure that the evidence before the court was sufficient for the court to make all of these findings. So if there's any limitation on the record or the evidence we have, that's not a basis to overturn the court's findings. Defendant had to meet his burden to prove ineffective assistance of counsel. And because he did not, and the court correctly found that he didn't prove deficient performance or prejudice, we'd ask that this court affirm. Thank you.
Let's talk about prejudice, and let's be very precise. Words matter in this room. Counsel said the plea offer was around readiness. It wasn't around. It was before readiness, to your point, Judge Lum. It came at the most propitious time for a plea, 1 day before the readiness conference. 2, the prosecutor didn't say she was unlikely to have accepted the plea. She said she wasn't certain she wouldn't accept the plea. That's not the standard. Finally, the trial judge did not say, the post-conviction judge did not say, trial judge was unlikely to have accepted the plea. He said it was unclear. That too is not the Strickland standard. No, I have nothing further unless you have questions. Thank you.
Thank you, counsel, for your arguments. The case will stand submitted and opinion will issue in due course. Thank you both very much. Counsel, you've argued here before. You should have gotten some oral argument instructions when you came in. Do you have any questions?
No, Your Honor.
Questions? Okay. Okay. And I know that you will be splitting time, I take it? Okay, that'll be up to you to figure out how your time is going to be split. Remember, 15 minutes aside. Remember, appellant, you're in charge of your own destiny. You got to watch your own time. I was going to say confidential or sensitive information. Let's not relay it because we're being live streamed and we're also archiving our arguments here. Anybody in the audience, please turn off their phone or cell phones or pagers so as not to disrupt arguments. Please give us your name and attorney registration number when you come to the podium. And I believe, absent any questions, I believe we're probably ready to go, and people in the interest of NA. Okay? Okay.
Good afternoon, Your Honors. John Poor, registration number 40395, here on behalf of Respondent Appellant DA. May it please the Court. A finding that no appropriate treatment plan can be fashioned to render a parent fit is virtually always a precursor to the termination of parental rights. Indeed, Section 193604B CRS suggests that denying a parent a treatment plan should only occur when an appropriate treatment plan cannot be devised to address the unfitness of the parent or parents. In other words, the parent is unfit and there's nothing that can be done about it. Due process requires that a parent faced with this outcome receive fundamentally fair procedures, including a fair opportunity to discover and rebut the department's evidence. That did not happen in this case. The department delayed in fully disclosing medical records and did not provide adequate expert disclosures.
Let me ask you, counsel, they delayed in disclosing the records, or they delayed in disclosing either a report or the contents of the one doctor's testimony?
Let me address that question in two parts, Your Honor, because I think it implicates separate issues. With respect to the records, there was not, with respect to the records, a pattern of intentional delay on the part of the department. But what did occur was that records that were necessary for father's retained expert witness to fully evaluate and reach his conclusions weren't initially disclosed, and that wasn't discovered until March of 2022, so well into the case. With respect to
What
opinions,
records were those, counsel?
specifically a bone skeletal survey that was necessary for father's retained expert witness to fully complete his opinion, and that wasn't disclosed until March of 2022. And whereas previous records had been disclosed much earlier than that, because the removal occurred shortly after August 1, I believe, of the previous year.
And when do we have the hearing in this case?
So the hearing took place when it finally took place, it occurred July 11th, 14th, 15th, and 22nd. And there's a lot to the timeline. So if I could, I'll proceed there and discuss a little bit the timeline, because it is important when it comes to the discovery, particularly of the department's expert witness and their opinions. So the March 17th is when expert disclosures were initially made by the parties. The expert disclosure that was made by the department, the proponents of termination, concerning Dr. Nicole Wallace down at Children's in the pediatrics unit, who essentially specializes in these child abuse cases, didn't say much of anything at all. It had a very simple statement to the effect that she may provide testimony based on her personal knowledge of the facts supportive of the CCDSS petition in dependency and neglect. That, coupled with their medical records, was it as far as a disclosure of Dr. Wallace's opinions were concerned. And the problem there, and the issue that father and his counsel ran into, is that the medical records in this case, which are extensive, reproduced throughout the record, particularly in the exhibits file, they've got a lot of information in terms of specific attributes that were discovered of the affected child during the workup, and they contain a statement that his injuries are consistent with non-accidental child abuse. The problem with that is that there's not information in those records that explicitly spells out how Dr. Wallace got from, here are the conditions that I observed, here are the features that I observed, here are the test results that I obtained, to the conclusion that these are non-accidental injuries. That's not information that's contained in those records. So there's a gap there in terms of discovery. So the hearing was initially set to go forward on March 31st. So that's months before the hearing actually went forward. It was continued on that occasion because of the unavailability of father's retained expert witness. It was reset, and the parties had intended to reset the hearing for April 29th, but the Fosters, who just intervened on March 24th, were unavailable. And incidentally, the Fosters didn't make much secret of their reason for intervening. They stated explicitly that they wanted to adopt the child. But the parties reset the hearing for June 22nd. Now on April 20th, so nearly 3 months prior to when the hearing actually took place, 2 months prior to when it was set to take place, Father's counsel reached out to Dr. Wallace to try to set a meeting to get information about Dr. Wallace's opinion. Two things came about as a result of that phone interaction. I think they played phone tag for a couple days, but they made contact, I think, no later than April 22nd. One thing that occurred was that Dr. Wallace disclosed that she wasn't available for that June 29th hearing, that June 22nd hearing, excuse me, so that produced another continuance. And the second thing is that she refused a meeting at that time and said, I'm not going to be available for that hearing date, so we're going to have to continue it, and also I want to wait till closer to when the hearing's set before I'll agree to meet with you. So the parties came back on April 27th, reset the hearing for the July 11th date. On or about June 3rd, Father's counsel, who'd been making efforts to meet with Dr. Wallace and not getting anywhere, started conferring with the other parties about taking depositions. And she took that request to the court on June 15th, and the court essentially said, so this is about 1 month before the hearing, the court said, no, it's too late for a deposition, but, if Dr. Wallace will agree to meet with you informally, that should address the problems.
Counsel,
Yes.
were you concerned about knowing Dr. Wallace's opinion as far as what may have caused these injuries, or were you more concerned, or was counsel below, more concerned with Dr. Wallace's opinion of Dr. Miller's opinion?
Both, Your Honor. I think both are probably equally relevant. When it comes to Dr. Wallace's opinion, again, my statements earlier regarding you have a lot of attributes that are identified in medical records, but not a real connection of the dots. That was a real concern. And in fact, in the June 15th status conference with the court in requesting a deposition, Father's counsel specifically discussed that issue and how much of a problem that was. With respect to Father's retained expert witness, that was also an issue. And the reason there is that, Father's counsel wanted to get information about Dr. Wallace's opinion of Dr. Miller's opinions, and had the court allowed Father to take a deposition, what I anticipate likely would have happened, and certainly would have happened if I'd been taking the deposition, is that Dr. Miller's report would have been put in front of Dr. Wallace, who would have, and Mother's counsel would have had an opportunity to ask not only generally, what do you think of Dr. Miller's methodology, but in addition to that, they would have had an opportunity to go through specific aspects of the report and find out what Dr. Wallace's criticisms and feedback would have been.
Counselor, I have a question there. Didn't Dr. Wallace testify 11 days before Dr. Miller? So by the time, do I have my experts confused?
No, I think you have it right.
Okay.
And that's true, that there was a delay between their bits of testimony.
Okay.
The significant prejudice and the piece that really I don't think could have been avoided without a deposition, but that a deposition would have absolutely enabled to have been avoided, is that on cross-examination, Dr. Miller, I believe it was the trial GAL, had asked on cross-examination Dr. Miller a number of questions about the report and identified some areas where there were potential issues with Dr. Miller's report, and what would have occurred had there been an opportunity to go over that report in advance with Dr. Wallace, is that Father's counsel would have had the opportunity to ask specific questions, which likely would have brought those concerns to the fore and allowed Father's expert to address those issues. But that did not happen because there wasn't an opportunity to take the deposition. So that was significant prejudice. The other thing that came about as a result of this is that the guardian ad litem filed what was essentially a 702 motion, a Rule 702 motion in disguise, the evening before Dr. Miller testified at 4:30 in the evening.
Couldn't the guardian ad litem have done that regardless of whether the other side had any expert at all?
Probably not, without complying with a meaningful deadline for pretrial motions concerning the striking of witnesses. The problem with this was that the guardian ad litem filed essentially a bunch of authorities saying that Dr. Miller's methodology didn't even comply with the Frye test, or that was applied in other states. And the concern there, again, was that there was no opportunity to respond to that because it was done so late. And then those specific things, including citations, were taken right out of the GAL's filing and put right into the court's order.
Pardon me for interrupting, counsel, but it strikes me that in order to qualify a witness as an expert, one of the things that an attorney is entitled to ask the expert is, well, does your methodology comply with the pertinent scientific standards?
Certainly.
And it would strike me that while the notice here was not generous, there was at least some notice. And counsel would be able to respond to this. when the expert testified.
I'm not certain that I understand your question. When you refer to there being notice, what notice are you referring to? Are you referring to the night before filing?
Yes,
Okay.
yes.
And certainly there was, and I don't want to overemphasize that particular aspect of the prejudice, because I think it's somewhat secondary to the fact that father's counsel didn't have an opportunity to discover Dr. Wallace's opinion and go through Dr. Miller's methodology with Dr. Wallace in advance of trial, so that she knew and had a good idea of what she was getting into in terms of what sort of attacks would be made against Dr. Wallace. And I think it's, again, I want to draw the court's attention to the fact, because I don't know that I've mentioned it explicitly yet, but when counsel met with Dr. Wallace on July 1st, Dr. Wallace flatly, number one, delayed the meeting substantially, waiting for a release, which she could have asked for well in advance of the meeting, knew what the meeting was about. And then in the roughly 45 minutes that they had left, flatly refused to disclose what her criticisms of Dr. Miller's methodology were. In a deposition scenario or in a longer meeting, but particularly in a deposition scenario, mother's counsel would have had an opportunity to not only elicit general criticisms of Dr. Miller's methodology, but also to elicit very specific responses to aspects of Dr. Miller's report. With regard to the discovery issues in particular, the prejudice is particularly acute because father's counsel did essentially everything right and went above and beyond when it came to disclosing opinions. She disclosed Dr. Miller well in advance of the hearing, made a full and complete disclosure of his report with exhibits. Even before his report was done, in her response to the motion asking for no appropriate treatment plan, she attached exhibits, including literature that Dr. Miller was relying on. So she basically did everything. The department did nothing in this regard. I mean, they gave a disclosure that would barely suffice for a lay witness disclosure. And you can take issue to some extent with the timeline in terms of how this was managed, but I think you see a consistent effort by father's counsel to try to get the information that she needed without unduly delaying the case, and she basically got frustrated at every turn. So finally, at the end, and I would encourage the court before deciding this case to reread the July 7th and July 8th motions for continuance that father's counsel filed shortly before the hearing, because they spell out in great detail what efforts counsel did make to try to rectify this situation, so that she didn't have to conduct discovery by trial by ambush. And People v. Robles, I think, is kind of the seminal case, but there are many from this court and the Colorado Supreme Court saying trial by ambush, discovery by trial are not supposed to be the way that we conduct judicial proceedings. And the problem in this case is that father didn't receive a fundamentally fair procedure. I'd like to save my remaining minute for rebuttal unless there are additional questions.
I have questions, but please stop the time on right now. I do have questions. And the question has to do is, and it's a fairly convoluted question, that's why I'm not going to eat up.
I appreciate that.
The question has to do with, as I understand it, no treatment plan can be designed, or under the statutes, no treatment plan would be designed if the father were responsible for injuring the child, assaulting the child in a certain manner. Is that correct?
That is correct. That statement is potentially problematized a little bit by the Supreme Court's recent decision in LS, but not for the purposes of this case, for reasons that I am prepared to deliver.
Second question I have, part of my convoluted question is, if, assuming, that fact had been established and that no treatment plan could have been put together for father, do the other issues in your appeal, less drastic alternatives and failure to follow up with a placement with the grandmother, are they moot?
No, they're not moot, because less drastic alternatives is independently, it's not a defense determination, but it's another factor that the court must consider and reject. And so I'm not aware of any precedent that flatly states that if you have I mean, in a less drastic alternative scenario, you always are confronted with an unfit parent, all the other elements
Yeah, but
required.
unfit parent with apparently no treatment plan can make the parent fit. Is there still room for a less drastic alternative to essentially save the parent from rights being terminated?
Yes, there is. I mean, there's certainly not a legal reason that would be precluded. And yeah, I mean, all things being equal, I mean, certainly the fact that there isn't a treatment plan is a factor that the court could probably consider when deciding whether or not to order a less drastic alternative, but it doesn't moot the issue.
Okay, thank you, counsel.
Thank you.
Good afternoon. Deborah Dodd, attorney, registration 28607, representing the children in this case, BA and NA. Well, I'm surprised to hear counsel today tell the court that the discovery violation was the skeletal survey, because that's not what was argued in the briefing. In the briefing, the argument was that because father did not get to depose Dr. Wallace, that was a violation. And so I don't want discovery to get conflated with a deposition. The briefing was, Dad wanted to depose Dr. Wallace, the court didn't allow it, that was the error. Essentially, I think father is saying, well, Rule 26 of the Rules of Civil Procedure should apply in dependency and neglect cases. But they don't. There's no right to a deposition. There's no statutory right, constitutional right. Even under criminal law, it's discretionary. And if the court looks at the facts of this case, clearly the court's decision in this case to deny depositions because Dad didn't ask for them until less than a month before the dispositional hearing was justified. It was not arbitrary or unfair. The records from Children's Hospital were disclosed in October of 2021, 9 months before the hearing. Dad never asked to depose Dr. Wallace when that happens. After he got the records from Dr. Wallace, Dad admits that the children are dependent and neglected in an injurious environment. So the adjudication doesn't happen. He admits that. But then when Dr. Wallace is endorsed in March of 2022, again, this was 5 months before the hearing. Dad does not ask to depose Dr. Wallace. There's 3 hearings after she was endorsed. Dad doesn't ask to depose Dr. Wallace. Finally, on June 15th, less than a month before the hearing, Dad asked to depose Dr. Wallace. And at that time, counsel says, well, I want to go over the medical records with her, medical records that Dad had received back in October of 2021. This was an EPP case. It was already 5 months past the EPP guidelines. Because Dad entered his plea in January, the dispo was supposed to happen in February of 2022. So here we are in June. Dad's just now asking to depose. The court made a very clear record that it's not in these children's best interest to continue this again. There's no way for you to depose Dr. Wallace, get the transcripts, and still have the hearing on time. And it's not in their best interest to continue this again, and it's an EPP case. So that was not an abuse of discretion. I disagree with father's characterization that this is a due process argument, because there is no due process right to depositions. And if
I just have a question, though, about the disclosure of the report. I understand that, CRCP doesn't usually apply or discovery, at least rules don't usually apply in dependency and neglect cases. But there was a case management order saying disclosures 15 days prior to trial. And I guess one of my questions is, would you agree that the disclosure of Dr. Miller, I'm sorry, I keep getting the experts' names confused. Well, Wallace?
Dr. Wallace.
Wallace, my apologies. The disclosure of Dr. Wallace's report or her testimony was lacking?
Well, I do disagree with that to this extent. So first of all, the case management order is not in the record. Dad didn't ask to supplement the record, but it is paraphrased in some of the pleadings. So assuming that the paraphrasing in the pleadings is correct, then what the case management order said is that, first of all, if you're going to endorse a witness, you have to include a CV, resume, or other qualifications. Well, in this case, Dad stipulated to the expertise of Dr. Wallace. So I don't think that that argument really holds water, that there was no CV attached. Now, the summary is very brief, but again, the CMO, if you believe the paraphrasing in the pleadings, says that written reports shall be provided, and if none, then a summary. Well, in this case, no summary was needed because there were 117 pages of medical records. And the medical records were very clear. I mean, this was a case with 5 fractures. 5 fractures. I mean, so there was x-rays. Dr. Wallace said, she signed the SBI form, and it said, I'm finding there's serious bodily injury, and I'm finding that there's child support or child abuse because there was 5 fractures. So I don't think that, granted, the endorsement was brief, but the issue of this case didn't turn on that summary. It turned on the 5 fractures, and that's an undisputed fact. And in fact, father stipulated to the serious bodily injury form coming in. So
Didn't Dr. Miller have access to those records?
absolutely he did. And Dr. Miller was retained in February of 2022. He had all the medical records. I mean, even at one point, Dad's attorney says, oh, wait a minute, I didn't know there was 5, Dr. Miller said there was 5 fractures. The records show there were only 2 fractures. Well, then the county attorney comes back and says, no, actually, 5 fractures are in all the records, and Dr. Miller even included them, all 5 fractures, in his PowerPoint. So Dr. Miller was acutely aware of the fractures. This position that, we needed, they needed to depose Dr. Wallace so they could ask her what she thought about Dr. Miller's theories. That's irrelevant. I mean, these are, battling experts, and the trial court had complete discretion to determine the credibility of the witnesses and to reject some and not reject others. So we have Dr. Wallace who says, in my expert opinion, 5 fractures is child abuse. And that's it. That's completely consistent with all the discovery that Dad received. And during the trial, Dad's attorney never objected to any of Dr. Wallace's testimony. Never says, hey, I didn't know that, that's new, that's a discovery violation. Doesn't object to that, that comes in. The county attorney and the GAL do not ask Dr. Wallace anything about Dr. Miller, Dr. Miller's theories, Dr. Miller's presentation, nothing. That comes out on cross-examination when Dad's attorney says, hey, what do you think about Dr. Miller? So that's how that comes in. And that's when she says, well, his theories aren't regularly accepted in the medical community, not only in a child abuse pediatrics, but in pediatrics in general. And then, as Judge Lund pointed out, there was 11 days after that testimony that if father at that point felt that he needed to recall Dr. Wallace, he certainly could have subpoenaed her to come back. I mean, he cross-examined her twice, but if he wanted more testimony to come back after Dr. Miller testified, he could have done that, but he elected not to do that. I mean, so, she says it's child support, I keep doing that, child abuse because of the fractures, and then Dr. Miller says, well, it's child abuse because of this metabolic bone disorder. The trial judge was free to judge the credibility of those witnesses, and in the end, he ruled that Dr. Wallace was more credible. So I disagree that it was a fundamentally unfair process by denying his late request for depositions in an EPP case. And I do want to just briefly address the no appropriate treatment plan.
The no pardon?
The no appropriate treatment plan order, because father does indicate in his notice of appeal that he's appealing both the dispositional order and the termination order. The briefing only develops the argument for the no appropriate treatment plan order. That is a dispositional order, and the Supreme Court said in January, in People in the Interest of LS, 2023 Colorado 3M, that the department does not need to prove who caused the injury. The only thing the department needs to prove by a preponderance of evidence is that SBI, that serious bodily injury, existed for the disposition. And in this case, Dad stipulated to the SBI form coming in. So as far as the dispositional order, I think that's moot by the Supreme Court's recent decision. I do want to, unless there are other questions.
I do have the question, similar question is less drastic alternative as placement with kin, are these issues independent of the determination about no fit treatment plan can be devised?
They're independent to the extent that after the court terminates parental rights, certainly the court can elect to place with family for the purposes of adoption. But when you have a parent that's unfit and a finding that there's no way this parent is ever going to be fit because there's no appropriate treatment plan for this parent, then I think the court does have to terminate. And then as far as placement with the relatives, can consider those placement with relatives after the fact.
But it's moot for purposes of termination? It's an independent issue for purposes you terminate, and the less drastic alternatives question no longer exists?
Well, the case law says that it's implicit in the statute. Typically it's under subsection 1C, which is you have the treatment plan. But in this case, there wasn't a treatment plan. So actually, Your Honor, I don't think that's decided. That's for you to decide. I do want to see the rest of my time for Ms. Padilla. Thank you.
Good afternoon. My name is Beth Padilla, and my bar number is 43520. In this case, I'm representing the foster parent interveners. I would like to address a few things that have been discussed today. One is as it relates to the disclosure issues in the trial court. So one concern that was raised by Father's Counsel today is that the guardian ad litem filed the motion as it related to Mr. Miller the day before Dr. Miller was scheduled to testify. I would direct the court to the briefings that, unfortunately, Father's Trial Counsel engaged in the same behavior rather consistently, filing motions hours before the trial was scheduled to begin. From recollection, I believe one motion was filed at 1:55 a.m. Before the first day of trial. So it's difficult, I think, for us to consider what should perfectly happen when there's sort of bad behavior on behalf of Father's Counsel in the trial court. There's been some discussion about Father's disclosures. While he did provide a very thorough disclosure as it relates to Dr. Miller, he provided no expert report for Ms. Handelman or Ms. Jihad. And the record reflects that I asked for that information, and trial counsel said, well, they don't have reports. So again, it's difficult to, I think, entertain these arguments that Dr. Wallace's didn't provide a report, and therefore something should happen, or she shouldn't be permitted to testify when Father's own expert witnesses did not provide reports.
Counsel, can I ask a very basic question?
Sure.
You're here on behalf of intervener foster parents?
Yes, sir.
Do foster parents have standing to intervene in the appeal?
So, Your Honor, my understanding is that they have standing to intervene in the trial court case, and that I think that they would then participate in the appeal. I think some of this argument was addressed by Father's Counsel in the motion to strike our response, citing the CWB case. Respectfully, I think CWB is not quite as broad as what the argument was in the motion to strike. CWB specified that foster parents cannot appeal a lack of termination order when the GAL and the department do not appeal. So in this case, we are in a very different position, that we are joining the GAL in defending the termination order. And in all candor, I thought we would be joining the department, but they're not participating in this appeal. So I'm not sure the basis for that. But I think that it is distinguishable from CWB.
Thank you.
Absolutely. I would like to briefly touch on the less drastic alternatives. I think there was some reference to whether there was a delay in exploring the paternal grandmother as a placement option. From reviewing the record, it appears that the home study was in the works as early as December 2021. Through that home study process, the record reflects that the grandmother requested to be a certified foster placement. That was above and beyond what Costilla County Department of Human Services had requested in the home study investigation. That certification then took longer and led to the delay in the final decision as to whether or not she was approved to be a kinship provider. And so I'd also like to highlight something that was brought up in the GAL's brief, that the report as to the home study indicates that the paternal grandmother was approved as a placement option, but did not recommend placement with the children, or placement of the children with grandmother. During the trial, evidence was presented to the court that the grandmother used her home as collateral to bail dad out of jail when he was charged with child abuse for the fractures relating to the child. And the trial court found that the grandmother lied under oath during her testimony as to something that wasn't especially relevant, but was in an effort to sort of protect dad. And so I think those are also important considerations when, if the court is going to consider the less drastic alternative argument, that we would submit there wasn't a delay, the home study was completed, and the trial court determined that the grandmother was not an appropriate placement because of her support of dad, as well as the children's incredibly high needs.
Don't parents normally support their children? Is that really that unusual that we can, ding somebody's credibility because they stand up for their child?
So the credibility issue was she lied specifically under oath during the trial.
And what did she lie about?
So the question was how father, this is from memory, how father came to court. How did he get to court? May I answer your question?
You certainly may.
Okay, I'm like, it's red. So the question was, how did father get to court? Grandmother responded that he used her mother's vehicle and transported himself to court. It then came out that indeed, actually, she transported him to court and they rode together in a blue SUV. So it's not the most important fact, but the judge was concerned that she was willing to lie under oath to essentially make her son look better.
Thank you, counsel.
Thank you.
May it please the court, I'm going to try to be quick. I want to address this credibility issue briefly. That there was with respect to the paternal grandmother's credibility, there was an answer to that was fleshed out in father's original opening brief, which was over length. The undersigned asked permission of the motions panel for extra words. The motions panel flat denied it. There's a response in that brief. It was stricken. It was not allowed. That issue or that discussion had to get lost in order to comply with the word limit. But there was an explanation for the grandmother's alleged inconsistency in the testimony that essentially would reconcile what wasn't really an inconsistency. With respect to LS, there's discussion about whether less drastic alternatives is still on the table. LS actually contemplates that a termination proceeding occur. If you read LS carefully, it contemplates a separate, that termination is a subsequent proceeding or a subsequent question even after there's a finding of no appropriate treatment plan. So necessarily you can infer that less drastic alternatives should be considered. Final thing, there's a lot of discussion about how long this case took to develop. There were delays. The record reflects that they were not father's fault. And yet at the end of the day, by and large, they were not father's fault. But at the end of the day, he got held responsible by not being allowed to do discovery. And the admission was made because he didn't want to have a trial and basically have findings when he didn't have his experts ready, so he made a no-fault admission.
Thank you, counsel. Thank you both, counsel, all counsel. The case will stand submitted. Opinion will issue in due course. That concludes our business for the day, and because of that, the court will be in recess and the bailiff shall so announce.
All rise. The court will be in recess subject to